which he submitted, he identifies his signatures. Now you see, I feel that professionally, nothing could be more blasphemous than this. You see, it is totally criminal. And you see, I feel that
the court has very rightly taken cognizance of this.
Absolutely correct. Now, but you see, the judge has called the officers.
That's right.
Tried to contradict them. Now, but you see, we have to keep in mind that the judge can play the role of a judge only. You see, judge cannot be prosecutor, judge cannot be the investigating officer.
This is about the best that the judge could do under
the circumstances.
Mr. Mongia, in the law there is a provision for summary trial of for perjury. Now this is a clause which is not used to often. Do you think if this clause was actually used, it would help?
No, I don't think, because perjury as it is, the punishment is up to 7 years, and in case of a case which involves death penalty, perjury can go up, the punishment can go up to 10 years. So I won't say that summary trial should be there. It should be a regular trial. After all, punishment is facing about 7 years or 10 years.
Actually, you're right, Justice Mongia, because in a lot of cases the witnesses are won over after a certain period of time.
That's right. That's right. That's right. Because as I said, money changes, political pressure or threat to life, etc., is there.
So perhaps making cases time bound would perhaps. Mr. Goyal, now there is a feeling that the punishment is too little. Now, what is the system in other countries? For example, you were a visiting professor in North Carolina University.
US, the federal law provides 5 years. North Carolina state, where I was, it provides 7 years. New York has increased to 15 years.
Okay.
So question is not only quantum of punishment, question is of the speed with which we punish the person. Like if you remember Bill Clinton's case, Clinton was punished when he was in the office, and he had to shell out $8,50,000 for a compromise. His bar license was suspended when he retired from the agency. If we invoke 344 here, particularly in case of government officials, even if we punish them for 15 days, he loses his job. So instead of initiating 340 proceedings for 7 years punishment and then making him free ultimately, it would be better to punish him in a summary trial by invoking power under 344, giving him a notice, adopt summary procedure, and give the minimum possible punishment, I would say.
I think Justice Mongia is not.
I won't agree, because the reason is his service is at stake. Therefore, why should there be a summary trial? After all, he has put in so many years of service.
That's the reason he should be on service. I
anyway, this is my personal view.
Justice Mongia is taking a more lenient view.
When the court comes to the conclusion that is perjured,
when the court says that the person has perjured, why should a person worry about his service?
Sometimes in 15 days.
There is another problem.
Yes.
In many cases, courts are not ordering prosecution of such persons who are residing from the state.
If sometimes in 15 days,
for the courts to order in the, because unless the court orders, there can be no prosecution for such offences.
That fear will actually.
So they should more often order a prosecution of such person.
Are you for summary trial for perjury, Mr. Virk?
Oh yes, definitely. You see, especially the recent cases where the police officers have resided, these are not excusable cases. You see, they were serious cases where it was necessary for the cases to reach a stage of justice. Now, you see, it is unacceptable where an officer says that I do not know what are the contents of the challan.
And it is clear, of course, the proceedings are still on in the court. It's very clear. Either the officer lied in the first place or in the second place.
Or he is lying now.
The finding given by the court always, I am prima facie of the view that he is perjured. Prima facie. Therefore, he is put to trial. That gentleman against whom this finding is there, he has to be put to trial, where he will be given chance to defend himself by producing.
I agree with Justice Mongia. The punishment is 7 to 10 years. It should not be summary.
344.
No, even
344.
The question is 344 will apply as far as Mr. Goyal's argument is concerned. That will be only against say public servants. All right.
Yes.
I said public servant is going to lose his job even if it is 1 day punishment.
That the fear required.
That's what I'm saying. Give him full chance to defend himself.
But if there is a fear like that, then officers won't be doing what they are doing.
Why we ask for summary trial? Why can't we finish the trial in a?
Maybe that's an even better suggestion.
As Mr. Goyal initially suggested, some higher court should monitor it. Please finish this trial within 1 month. Please finish this trial within 2 months.
Politically sensitive cases are otherwise important cases. which are not politically
So either make them time bound or maybe transfer them to another state or perhaps to the CBI.
I think somebody should file a PIL in the Supreme Court, and Supreme Court should issue a judicial order to all the high courts that such cases which should not be more than 30, 40, 50 in a state. On one particular date, all of them should be listed, and let the people show, let the authorities show.
That's a very interesting suggestion. Now, Mr. Goyal, there is no provision in the Evidence Act to cross-examine the witnesses who turn hostile. Do you think such a provision should be there? I believe in certain countries there is a provision like that.
There is a provision, and not only that, like in US, if a person is faced with two statements which are contradictory, then without reaching a finding which statement is correct, he can be straightaway punished. There are 3-4 cases, particularly in 79 and 82 and 96, where the persons were punished merely because they had made two contradictory statements.
Under the Evidence Act, as far as the hostile witness is concerned, the only provision is he can be cross-examined with the permission of the court. And 99.9% permission is granted. I am telling you, permission is granted because his statement which has been made before the police, though it is not admissible, the prosecutor will say, this is the statement he made before us, that means investigating agency. Yes. Now he is resiling and taking a different stand. He should be permitted to cross-examine, to come so that he can see what is the truth. So there may not be a provision, but the provision, as I said, was with the permission, and it is granted. And mind you, there is on the evidence, the court can still convict on the basis of the evidence of hostile witness also, because he can say, grain from the shaft, he will say that in fact he is not telling the truth now, and in the cross-examination truth has been brought out, and he can still convict the person on the basis of the statement which is brought out in the cross-examination.
Right. Mr. Dogra, now a lot of witnesses resile because they are threatened. And I think there is, as of now, there is no witness protection program, as Mr. Goyal brought out. But there is a proposal to amend the CRPC and the amendment to provide for punishment for threatening the witnesses. Do you think such a proposal should be brought about?
It is a positive step, some step forward. It should be done. But I think our investigations and our courts are too dependent on witnesses only. We do not go in for incriminating evidence, or technology-based evidence, human intelligence. The court should not be solely based on the witnesses. Let them examine the other incriminating evidence so that the truth can be found out. So it will be great help to the court, also to the investigating officer also. We in Punjab also take the statement of few witnesses and put the trial challan in the court.
The protection program is very important in many of the foreign countries. Witnesses are reallocated after they give evidence. Their identity is kept secret in many cases.
That's right.
So witness protection program is very important.
About threatening of witnesses, we have already introduced 195A in IPC. And this is now punishable.
That's right. It was
it's now punishable.
Can be relocated, can be very, very important cases.
True, but we are talking of important cases. This has come to the center stage only because of important cases.
Absolutely. Mr. Virk, now we noticed that in a lot of cases where the officers are involved, do you think there is need to have a separate law to deal with the officers who reside from their initial statement?
I don't think there is. My feeling is that under the existing law only there are sufficient provisions to prevent officers from resiling, as has been done recently. Now, you see, as Justice Mungia was saying, there is a practice of declaring the witness hostile and then cross-examining him. Now, I personally feel that why did the prosecutor not declare the witnesses in this case hostile and cross-examine them? It was necessary. Now, but what happens is that when the person in authority is the accused, how do you do it?
Political control over the executive wing of the state, this is leading to lots of ills in the society, and a time has come where we should have relook on this and complete separation of powers, as I said that time, between the judiciary, the executive and the legislature. I think this we should look at.
Complete separation of powers between the judiciary and the legislature. So that important principle that exists.
So it doesn't exist. So that the minister, you see, who is also a member of parliament or an MLA, he is also he is heading the department. So in day-to-day administration, the ministers.
So you have some kind of structural changes in the way the
even within the executive, the prosecuting agency should be completely independent. So there is no pressure on the prosecuting agency. As in this case,
so the prosecuting agency should be under who?
Under whom? Under the
state government body.
It
Like Central Business Commission.
It should be an autonomous body.
Whenever we say in the court, please hand over the investigation to CBI. Why? Because CBI is considered to be independent
Or political pressures.
of political pressure.
Only comparatively. That's lots of allegations.
No, it is comparative. It is
also.
comparative in this our system in India. Perhaps political pressure will be always there, even if you may
Yes. So
say
this is what I said, that let's separate the executive from the political control, and executive will not.
But I thought separating the prosecution would be an easier option. I
Maybe
think.
because that can
Even
be done within the.
Mr. Virk, separating the prosecution from the executive, is that possible?
You
Should it happen?
see, it is possible. But now you see what I was trying to tell was that even in the present law, you see the entire chapter 11 of the Indian Penal Code deals with offences relating to false evidence and public justice. Now, you see, I feel there are enough provisions. Now, as I was talking about this, you see, re-employment of the officer. Now, is it not a favor to him? After his retirement, he is re-employed. Now, anyone who gives a gift or shows a favor with a view to have screen that officer, a culprit from legal action, you see, it is actionable under 213 of the IPC.
Apparently, the law is not being
There are
enforced.
very large, elaborate provisions under the law.
219
The
deal
question
with
is,
the public
who will
service.
apply?
The problem in India is just
Justice Mongia, a lot of feeling that there's a feeling that the courts are not, enforcing the law hard enough.
I initially said this is one of the causes why the witnesses keep on resiling from the statement.
Even on the
Courts should be really stringent on this matter, and 1, 2, 5, 10 examples.
But who is to make the courts more stringent?
The court themselves.
No, I'm telling you,
under the even
the judiciary itself. Some judiciary itself should do this.
Apparently, that is not happening, Justice Mongia.
That's what I'm saying. The apex court should
even
pass
under
a
Yes, quickly we're going to, we're
even
running out of time.
under the
Mr. Bora.
departmental provisions, stringent action can be taken against the officer who has resigned. It is unbecoming of an officer. That is serious enough.
but very difficult to say.
The question is the willpower to proceed against the officer.
No, but
Last
which
word
state-
from you,
which-
Mr. Virk.
Now, you see, we are all talking about bringing about a change or improvement.
Yes.
Now, you see, who has to bring this improvement? Now, obviously the government. Who is heading the government? The person who is the accused in the case. Do you think that improvement can be brought about?
That may be the present
See,
situation,
see,
but
no,
tomorrow you see.
You see, what I'm trying to tell you is, I would like to sum up with a मेरा मुंसिफ ही मेरा कातिल है, क्या मेरे हक में फैसला देगा? Now, do you expect improvement when such circumstances prevail?
My point is the governments will come and go. We have seen the governments, earlier government, the new government, any new government. The things remain the same. Political interests remain the same. So the question is, it has to be made up apolitical. Beyond the political system.
That we all agree, but how to do it, Mr. Goyal? What needs to be done? Last word.
We need to approach our jurists and our parliamentarians to introduce new laws, particularly like Victim Protection Act and Witness Protection Act, and to incorporate something which instills a strong fear in the mind of false witnesses.
Would you like to add to that, Mr.
I will advocate for complete separation of powers, an overhaul of our constitutional system.
Right. Thank you very much, gentlemen, for joining us in this discussion. Of the various ills eroding the criminal justice system in our country, witnesses lying under oath is perhaps the most serious. Unfortunately, very little is being done to check this insidious practice. It is time the courts enforce the law on perjury in letter and spirit. With that, we end this edition of Day and Night News Prime Debate. We meet again tomorrow with another issue. Till then, good luck and goodbye.